Given that the defendant has no reasonable expectation of privacy in the cell phone records of the Hertz Corporation, he has no grounds, no standing. He has nothing that permits him to come in and argue that the court should somehow find that the state's method of obtaining those documents was somehow improper. Additionally, Your Honor, the documents were turned over to the state by the Hertz Corporation. If the Hertz Corporation wanted to contest the release of its own documents, the Hertz Corporation and only the Hertz Corporation, and all that they released, I will also make clear, it's not at all anything comparable to information contained in cell site location data that a person has within a cell phone that is kept on their person and that moves around with them. These documents are simply documents that show that the defendant rented from Hertz a particular vehicle at a particular time and returned said vehicle at a particular time. There's no location information data to which the defendant could in any reasonable way have a reasonable expectation of privacy. Additionally, Your Honor, again, the records do not belong to him. He has no standing, no expectation of privacy in them, and he is not properly before the court contesting or moving that the court suppress the release of Hertz's own records to the state. So again, as well, Your Honor, the law on standing requires that the defendant show that he has standing, and his claiming that, just baldly claiming that the information sought somehow references or, as he put it, it touched upon the defendant or information concerning the defendant, still does not give him any standing to argue or ask that the court suppress information lawfully turned over that he has no expectation of privacy in. Even if it was unlawfully turned over, he cannot argue that the court should suppress these documents. He does not have standing to move the court to suppress the documents. There is no infraction of any law or code of conduct. There is no incursion on any protected rights held by the defendant. That he is.
Yeah, it looks like from Kessler that he has a reasonable expectation of privacy in a conversation. He doesn't have the reasonable expectation of privacy in records. So is that kind of sum and substance what your argument is now?
Yes, that's an initial matter, yes. And I mean, I'd ask the court rule on his lack of standing before we do anything else related to it. Thank you, Judge.
Okay. All right, Mr. Steele, what say you about standing? It looks like that these are the Hertz records, correct?
Yeah, they're included, that's true.
Okay, is that what you were, as an initial matter, I would agree with Ms. Lovely, your client does have to have standing. I would agree. I would also tell you that conversations are different than records. So tell me why you think that he has standing to contest these records.
Okay. Well, and when the Honorable Court started to get into this motion, it actually the court actually asked about Mr. Williams' motion to dismiss the indictment and or a motion to suppress evidence and derivative evidence based upon prosecutorial misconduct and abuse of grand jury powers. That was filed on November 3rd, 2022. I supplemented that, Your Honor, on November 10th, 2022. It's the same title, but I wrote supplement to Mr. Williams' motion to dismiss the indictment and or a motion to suppress. It also goes hand in hand, if you don't mind ruling at one time, I believe it goes hand in hand with the Mr. Williams' motion to suppress. Number 3.
Well, I need to deal with the issue of the phone records. That's what you asked me to do.
The Hertz records,
The
Joe.
Hertz records. So let's deal with the Hertz records first. There may be other issues as to the indictment and some other things, but let's deal with that first. Client's got to have standing in order to address that particular issue.
So I raised it twofold. I raised the motion to dismiss the indictment based upon prosecutorial misconduct. Records of another company, although we want to assert standing, Maddox and DDOS versus State says that there is no standing in those records. So I will, under the current case law, I'm not waiving the issue, but I'm telling the court, like I'm obligated to do, of the case law, and Maddox is.
So you would agree the state's proposition is correct?
I would agree that.
But you disagree because you represent Mr. Williams. Am I correctly, summarize that, sir?
Well, it's not like because I represent this, I think the law is inaccurate, but the way I understand the law today, we have to follow MADDOX versus State 346 Georgia Appeal 674 2018. It's exactly correct what Ms. Love said, that there's no standing in records of a corporation when you rent a car. But that really wasn't my issue. That's why I supplemented it. And that's why I did the separate motion to dismiss the indictment. And
Judge,
the reason,
if I may, and I do apologize to Mr. Steele, but I hear him going into the substance of a thing that necessarily relies upon his right to complain about the state's method of obtaining the records from Hertz. So I would ask that.
Let me deal as a preliminary matter, threshold matter. If that's the case, the records, your client would not have standing. I would grant the state's motion as to that, as to the Hertz records.
understood.
Okay, so is there any other basis that you are asking for at this point in time?
Yes.
Okay, all right, what's that?
Okay. So, and the reason I want to call Mr. Sprinkle, if you allow me to briefly proffer. I just
Okay, you're going to proffer as to why you need to call Mr. Sprinkle.
Yes, because I think that's where it starts. So what happened is, Your Honor, is Mr. Williams is wrongly targeted by law enforcement for 10 years, since he's 21 years of age. And during those 10-year period, there's a systematic abuse of process by the people who claim that other people break the rules, and that's the District Attorney's Office of Fulton County. And what I'd like to call Mr. Sprinkle and prove to this honorable court is as follows. First is what you just heard from. Law enforcement officers and the District Attorney's Office is aware that the Honorable Judge Newkirk found that law enforcement had no right to go into Mr. Williams' home in July 15, 2015, take devices. The prosecution does not restore those devices. You already ruled, I know Judge Newkirk ruled, but that's part of the issues. What right does the prosecution, the District Attorney's Office, have to keep that property and then to send it to Cellbrite without a warrant and have it searched? I want the court to consider that. Then I want the court to consider the following. The fact that the District Attorney's Office did not go back to a judge and say, we have this property, we're supposed to give it back. We are doing another investigation, we want another search warrant. They just go and Cellbrite, I would introduce through Mr. Sprinkle, says, as a courtesy of the District Attorney's Office, we're going to look at this device. I would like the court to have that in its breast when deciding whether there's extreme prosecutorial misconduct. Then what happens is grand jury subpoenas. I'm not moving to suppress anything at this point. I'm not waiving any argument, but I'm not moving to suppress. But this is how the grand jury subpoenas were given out in this case. And it's not only Hertz, it is every grand jury subpoena. I've attached them to the motion. And what the grand jury subpoena shows is that from his office, presumably Mr. Sprinkle is on every one of these, he has a district attorney's seal on the subpoena. The law requires the clerk to seal a grand jury subpoena. Mr. Sprinkle sends all of these subpoenas outside the state of Georgia. There's no authority for
That Mr.
a,
Steele indicate which subpoenas he is referring to when he says all are, because the only one that I'm aware of that he has referenced is the Hertz subpoena to Florida. But as a matter of fact, I would just let him continue, and I will not.
Yeah, he's proper in some one.
Oh, he is actually
Why?
25. He is. Subpoenas that he is complaining to the court about.
Okay, so Ms. Love's argument is, and the court's inquiry of you is, what reasonable expectation of privacy do you have, or standing do you have in these records?
this is not the issue. This issue goes to dismissal of an indictment for prosecutorial misconduct. Mr. Williams was indicted. I'm not trying to suppress the evidence based upon your ruling and the case law. What happens now is there was such egregious misconduct by the district attorney's office.
So you're saying you'd like to examine Mr. Sprinkle for his motives, or for as to why he sought these particular documents in his prosecution.
I want to subpoena, well, I have subpoenaed. I want to call Deputy District Attorney Mr. Sprinkle, because I want to ask him why he believes he had any right, which I'm contending violates Mr. Williams' rights to due process as stated in State versus Lampel, Lampl, 296 Georgia, 829. It's in Division 2, 2015 case. It's in my motion entitled Mr. Williams' motion to dismiss indictment and or motion to suppress evidence filed on 11/3/2022. And what the Supreme Court of Georgia held was it is an extreme remedy to dismiss an indictment or a count thereof. However, it is a remedy. It's a due process violation. When the state's talking about standing, you can't have more standing than all of these people here who are indicted, wrongly indicted based upon the misconduct of the district attorney's office. And we don't have to sit here and allow the district attorney's office to violate the law and just put us in an indictment without this honorable court hearing it. And if this honorable court finds that it reaches the level of outrageous prosecutorial misconduct by the systematic abuse of process by our district attorney's office, then the indictment is dismissed. The state is arguing something that has nothing to do with this motion. This motion is not a motion to suppress. It is a motion based upon a violation of due process rights because everyone here, I assume, joined the motion. Everyone here is suffering from the state of Georgia's unlawful abuse of their power.
What's
That's the
Lample's
issue.
site again?
Mr. Lample's site is (296) Georgia, 892, Division 2, 770 Southeast 2D, 629, 2015. I had the honor of representing Mr. Lample. On that case, it went to Court of Appeals of Georgia, then the state sought certiorari, and that's how the Supreme Court got that case. He's the mayor of Amara. Mr. Lample's the mayor of Amara.
Okay.
And that's why I would like to call Mr. Sprinkle, because he's sending out, under the auspices of a grand jury subpoena, with the district attorney seal, without the clerk seal, outside our state. They're taking evidence from Mr. Williams' home, not returning it, searching it, regardless of Judge Newkirk's finding. And then, Your Honor, what I'd like you to consider, and Mr. Sprinkle would be asked, there's a recording in a grand jury, and it happens on June 15, 2018. Mr. Sprinkle and law enforcement officers who were present in this courtroom subpoenaed a woman named Ms. Morton, M-O-R-T-O-N. They brought her before the grand jury in Fulton County. They didn't like that she wasn't talking with them. They put her under oath. And they said, it's Mr. Sprinkle is said on recording right at the beginning. It's at 10 seconds of the recording. He says, because in Georgia, it's not an investigative grand jury unless the court deems a special purpose grand jury. It's not federal court where you could do an investigation. The state of Georgia, you need a proposed bill of indictment already against the person and what the charges are. State of Georgia versus Brian Steele, here are the charges. What Mr. Sprinkle tells the grand jury is, this is not an indictment under consideration. We are just here to hear Ms. Morton testify. That's not valid. So I'd like to ask Mr. Sprinkle what right he had to use the grand jury as a district attorney's investigative tool. Those are my five issues. The search warrant, the search of the devices, which we already ruled. Why did that happen? Why did the subpoenas come without a clerk? Third one is, why would the subpoenas go outside of the state of Georgia? The fourth one is, why wouldn't you return the property? And the fifth one is, why would you bring a human being before a grand jury when you don't have a real bill of indictment, and you tell the grand jury that this is not a bill of indictment under consideration? What right does the district attorney have? And that's why I subpoenaed the young man.
Okay.
Your Honor, the defendant still has not addressed the issue of standing as to any of the.
He's indicted.
No, Your Honor. The conduct that he is complaining of, he has to have been agreed. He has to have an expectation as it relates to that conduct.
I think that's what he's asking me to test. I think that's what he's asking me to test, and he's also saying, hey, he's an agreed person because he's under indictment for these bigger charges. So,
and Your Honor, if I may, I don't know why Mr. Steele cited Lample in its brief, because it actually supports the state's position in this case. In Lample, a special purpose grand jury investigated the defendant and subpoenaed that defendant. In this case, it isn't even that the defendant was subpoenaed to testify. He is talking about a person who didn't even yield information that was used against him. He is asserting that actions that he has no right to complain of should be somehow used as a basis for dismissing a lawful indictment against this defendant. So he is, I guess, attempting to leverage the court's ruling previously into something that simply doesn't exist. He does not have a right to complain of the actions he asserts were unlawful or improper. He simply doesn't. And he hasn't addressed his being indicted alone does not give him standing to argue or to complain about the fact that Ms. Morton was taken before a grand jury, or that a subpoena was sent to a corporation or a company or an entity that the defendant has no expectation of privacy in. He simply doesn't get past that initial threshold. And by continuing to fold one argument into the other, he attempts to subvert what the court's Supreme Court. They've been indicted, and when the Georgia Supreme Court says, nope, you lack standing, it being indicted doesn't afford them standing to argue about matters that they have no right to complain about. And so he has bundled up a whole bunch of matters as they relate to other entities. Frankly, with respect to Hertz or any other entity, they can simply give us the documents we requested them. They could literally email them to us, as some of them will do. But the only entity and the only people that have a right to complain about that, and right now he's skipping over the fact that he has no right. He's asking you to jump right to, let's just get into the substance of the argument. And that is not the way that the law works. Mr. Steele is well aware of that. He is a very seasoned attorney. And he is attempting to escape that fact by just pushing forward and conflating all the arguments and making sure that they collapse into one mud pie. But Your Honor, I believe, and I'd ask that the court address that threshold matter before we get into anything else. And specifically, before we begin bringing assistant district attorneys in to talk about what could constitute work product, and to discuss matters that have nothing to do, that are in no way matters that the defendant has a right to complain about.
All right, well, excuse me a second, please.
I'm on mute and I'm just listening. I'm not doing anything, but I have to listen to this. Sam's got a project and it had to be printed on a poster. The poster printing printer at FedEx is broken, so is the one at Office Max.
Mr. Bailey's, not Mr. Bailey, but Mr. Sprinkle, you're challenging by way of the evidence that you were presenting, or that I said you didn't have any standing to see what Mr. Sprinkle in fact did present to that grand jury and what he told them. So
I actually won't do that. What I'd like to do is, why did Mr. Sprinkle serve grand jury subpoenas? Why did he do the process the way he did? I'm not going to ask anything about what happened in grand jury, except I have that recording that was given to us in discovery.
Was it discovery?
Yes. Okay. Will not ask anything about what occurred in a grand jury, except what was given to Mr. Williams in discovery by the state of Georgia. It's a recording.
Wes, do we have a copy of the motion to suppress? Yeah, that's what the motion was. Okay, I ruled upon the issue of the all right, I think I'm back on at this point in time. In terms of the motion to quash the business records, I'm also going to grant the motion to quash the subpoenas, both subpoenas 1 and 2. The court is of the opinion that of the relevancy of these particular records, but also they're protected by work product under 24-5-501. And for those reasons, I'm going to I'm going to grant the state's motion to quash on those two subpoenas. All right, anything else?
Thank you, Your Honor.
All right. I have some proffers I need to deal with. Let's see, Mr. Where is he? Mr. Hoover?
I'm sorry, Your Honor, before we do that, I just want to bring the court's attention. Mr. Kendrick has both to suppress statements on the record. We have a witness here, a spoken counsel. He doesn't intend to go forward on that motion.
He does not intend?
We were hoping we could release our witness who's in here with that.
Yes, any objection, counsels?
No, just to be clear, we're not withdrawing the motion, we would just like to argue that on another time.
And your name again, I'm sorry.
Doug Weinstein, W-E-I-N-S-T-E-I-N.
Mr. Weinstein, what's your client's name again?
Giovanni Kendrick.
I'm sorry, Your Honor, we're just hoping our witness might be able to go.
Well, you know, folks, I'd like to be able to accommodate everybody, but you saw what happened this morning, okay? We had a technology glitch that nobody could have foreseen, I should say, and we're kind of a little bit behind. So we're a little bit behind in terms of just being able to properly conduct court. So, what is your motion? Your motion is to suppress?
Yes, Your Honor.
Could you give me just a few minutes and I can maybe have that motion heard since your witness is here?
No, Your Honor, I believe he doesn't want her today, and we don't object to a continuance.
Oh, okay, all right, so your motion is suppressed, all right, we're gonna, okay, all right, I understand,
Thank you, Your Honor.
I'm with you, okay, yes.
Your Honor.
You give a mouse a cookie, what is it you want, Mr. Short?
Thank you, Your Honor. I just wanted to make sure that I respect the record. I know that you have not ruled on the
It's not
motion.
your turn yet.
Well,
You
I
jumping
have-
in front of Mr. Steele now?
no, I am not jumping
Okay,
in front
okay,
of
okay, all right. What
Uh,
is it you'd like to tell him?
well, I filed the exact same motion that Mr. Steele filed
And then
regarding
your client is, sir,
Stillwell.
Mr. Stillwell,
And that
okay.
was filed on November 16th. And
The motion to dismiss the indictment
motion to dismiss the indictment.
and motion to suppress evidence. You wish to table yours at this point in time?
I have not heard you rule on the actual motion, just on the subpoenas. And I would just point out to Your Honor that our argument is not based on any Fourth Amendment violation that would require standing, but rather the prosecutorial misconduct, which I believe as citizens of the United States, we all have standing to challenge. And Mr. Stillwell, who has been indicted and investigated in part by illegally issued subpoenas.
I'm gonna deny the motion to dismiss the indictment, okay?
Okay, well, I just wanted to make sure it was on the record that I too have filed that motion and.
All right, I'm with you. Okay, all right. So to the extent that's been ruled upon, that's fine. Anything else?
Actually, Judge, just while we're here for the record,
Yes, Mr. Menace.
I have failed to adopt the motion as writing, but I did want to respect the record that that's on me, and that was effective, that he want to orally also adopt Mr. Steele and Mr. Sharp's motion.
All right. Well, you probably should reduce that to writing, but Ms. Rosenwasser, if you will include that in order, please, madam.
Yes, Your Honor.
Yeah, I'm gonna, in the motion to suppress and motion to quash, okay?
And Your Honor,
You can-
would you allow me to incorporate Mr. Steele's argument into the record on behalf of Mr. Steele as well, so I do not need to cite to the city cases and,
Yes,
thank you.
so we'll include you as well. Okay, anybody else? All right. Okay, before I was interrupted by Mr. Sharp, Mr. Hoover.
Yes, Your Honor.
Okay, do you have the issue of the proffer that you'd like to complete at this point in time? I was gonna ask you to complete that issue of the proffer. And then also, if there's anybody else who we still need to deal with the issue of the proffer.
I'm not sure which proffer.
Ms. Rosenwasser, you want to address that, please?
Your Honor, I believe the court is referring to your continued, Mr. Hoover's continued representation of Mr. Sumlin after, you were disqualified as to Mr. Blaylock, to see if Mr. Blaylock was on board with you continuing to represent Mr. Someone.
Well, Mr. Blaylock's attorney is here, so if the court wants to continue, we can at this point.
Where's Mr. Black's attorney?
It's me, Attorney Justin Hill, Your Honor.
Is it Justin Hill?
Yes.
Okay.
And
And you were counsel for, I'm sorry, Mr. Hill, I apologize.
I'm sorry, can you say that one more time?
You're counsel for whom, I'm sorry?
Mr. Blaylock.
Mr. Black, okay, all right.
Demond Blaylock, yes.
All right, Mr. Florence, do you have a copy of the proper?
my computer, I can take a photo.
Could you please, ma'am? I don't think I have it last year. Huh? Oh, yeah. We kind of jumped the gun a little bit, just to, so that myself and Ms. Weaver are in sync as to who is present today and who's representing whom. Could we just take roll call as to who's here? So we'll start out with my left, your right, gentlemen. Or ladies, if you're representing anybody, could you kind of state who you are representing, please? Okay, all right. All right. Okay. That was right.
Adrian Love for the state, Your Honor,
Okay.
Deputy District Attorney.
Yes, ma'am.
John Foley from the state.
Deputy District Attorney Simone Hilton for the state. Assistant District Attorney Lizzie Rosenwasser for the state.
Okay, all right. Now for the defense counsels and their clients. All right, we'll start off, Madam. I forget on the right side.
Chelsea Golden from Mouse Farley.
Thank you, Madam.
Anastasio Smenez for Mr. Mouse Farley.
David Ross, Shannon Spiller. Max Shard, for Shannon Spiller.
Keith Adams, Jeffery Williams.
I'm Brian Steele, I'm also the Iowa representative.
Okay. All right. Counsels in the back, anybody representing anybody here today, Madam? In the orange? Yeah. I'm sorry, one more time? Yes, ma'am.
Gina Bernard for Jaden Myrick.
Michael Russ for Mr. Bear as well. Good afternoon, I'm Sweetie Shout out to God, Mr. Dorsey.
All right, continue to the center.
Doug Weinstein for Mr. Demonte Kendrick.
All right. Hold on, Mr. Harvey, I think it's you.
Oh, go ahead.
With Mr. Nelson, along with Nicole Westmoreland, she is on the Zoom. You can see that she is on the Zoom.
Yes, sir, thank you. All right.
Angela Lee Williams for Mr. Ryan.
Thank you, madam.
Sean Hooper, Francis Allen.
Okay,
Justin Hill for Demond Blaylock.
all right. Continue, madam.
Christy Gladden for Trontavia Stevens.
Thank you, madam. All right, anybody else to my left, your right? Okay, all right. Just want to make sure who's here along with clients today. All right, okay. Thank you very much, counsel.
My name, I apologize. I'm here on the platform, Tiana McCallum, on behalf of Mr. Khalif Adams.
Okay. All right, anybody else on our Zoom platform? I'm sorry that we've had such difficulty with it today. Anybody else? Is your client, Mr. Adams, on the platform as well?
He is not that I see, Your Honor.
He's in the back row.
He's in the what?
He's in the back row.
He's here actually in court. He's in the gallery, madam.
Thank you, Your Honor.
Okay, all right. One more time, counsel, your name. I apologize, madam.
Tiambre Calland.
Well, and could you spell that for us, please?
Sure. First name is Tiambre, that's Teombre. Last name is Calland, Calland.
Okay. All right. Okay. All right. Okay. All right. So we're talking about profit. So Ms. Rosenwasser, do you have that?
Yes, Your Honor, I was able to locate a transcript from a previous hearing.
Okay, all right. So can we take care of Mr. Blaylock's proffer at this point in time?
Yes, Your Honor.
All right, let me go ahead. Mr. Blaylock, where are you, sir? Can I get you to raise your right hand for me, please, sir? Best Chair, would you solemnly swear or affirm the evidence you'll give in the matter now hearing should be the truth, whole truth, nothing but the truth, so help you God so affirm?
Yes, sir.
All right, you put your hand down. Sir, we're just gonna ask you a series of questions just related to the proffer, nothing else. And then after that's done, I'll make a decision as to you and your counsel, okay? All right, Ms. Rosenwasser, if you go ahead and read that particular cover, he's already been sworn, so.
Sir, I recognize you're currently being represented by, I'm sorry, your name, sir?
Justin Hill.
By Mr. Justin Hill, is that correct? And sir, were you previously represented by Mr. Sean Hoover? Are you aware that Mr. Hoover is still representing your co-defendant, Mr. Antonio Sumlin? Okay. Now, have you been advised of a potential conflict between this attorney still representing Mr. Sumlin? No one has advised you of a potential conflict?
Oh, yeah.
So, yes, someone has spoken to you? Okay. Is that your attorney right now who spoke to you about that? Okay, who spoke with you about that?
Mr. Luis Rivera was the second.
Okay, did a woman, Ms. Rivera, speak to you? I'm sorry, sir, I'm being confusing. Has another attorney, anyone other than these two guys, ever come and talk to you about this case? Okay, was it an attorney as far as you know? Okay. Did she explain to you that there is a potential conflict with the agency? Okay. Are you aware of, so you are aware of that conflict? Okay. You understand, that you have had, even if you have had meetings with this counsel, Mr. Hoover, you still have no objection to him continuing to represent your co-defendant? Okay. And you met with someone else independently outside the presence of Mr. Hoover or your current counsel about a potential conflict of interest, is that correct? Okay. And you have stated that you waive any potential conflict and you wish for this gentleman to remain your counsel and you waive any conflict with your co-defendant being represented by Mr. Hoover? Okay. And has anyone promised you, threatened you with anything, forced you, or in other ways forced you to consent to this? Okay. Do you waive any other potential issues, so including that anything that this counsel has learned from you could be used in your co-defendant's defense? You don't waive that? I'll try again. Do you understand that if you went to trial, anything that he learned when he was I believe that covers all the waivers.
Mr. Hoover, Mr. Lee, what is your representation?
Your Honor, at one point he had an attorney. I'm not sure if that attorney was withdrawn. It was for Larry, anyway.